times has the court said bare bones? The court has essentially just said to counsel, hey, counsel, there were a whole bunch of ways you could go about this, and the way you went about this is not sufficient at all. It is a bare bones motion without an affidavit, and it's not even asking for the thing you're asking for an oral argument. So what do you want me to do? It is procedurally improper. So how can I do what you're asking me to do when you didn't ask for it?
Excuse me, bare bones motion that's not supported by an affidavit.
I swear he said bare bones motion at least 4 times. When the court has said bare bones motion that much, you're on the losing end of whatever is about to happen, because the court is like, no, this motion is insufficient.
If the court will accept it, I'll file an affidavit by the close of today, and I'll file it under seal, and I'll lay out what my specific thoughts are based on the review of what's been provided.
Right now, I don't have enough, for sure, to issue an order contrary to Judge Casper's destruction order.
I'd ask that be done in 45 minutes, Your Honor. We have had this date for well over a week. There is an index, which I'm going to ask the court to.
Okay, we haven't had this hearing for well over a week. It's been like a week. But the prosecution is saying, Your Honor, if he's going to file more, we need an opportunity to respond. The deadline looms large. Literally, why couldn't this have been done yesterday?
Consider as you're making this decision that Mr. Tipton has, and certainly he could have filed a motion under seal that had more specific information in it, but we do not have time. The Commonwealth has continually been faulted for taking its time. But I would ask that be filed by 3 o'clock. I will wait, and then we can have further hearings on this today.
No. What?
Mr. Tipton,
Yes, Your Honor.
did you hear what Attorney Beatty was just described, just saying?
Yes, I did.
Okay. Can you file something today?
I certainly can.
Okay.
But I heard her say 3 o'clock,
What?
and I will do everything I can to get it filed by 3 o'clock.
We'll put this on for a second call.
This hearing started at 2 p.m. Eastern. She's like, file that affidavit by 3 p.m. Eastern, and we'll put this on second call, meaning we'll come back to it. Oh my God.
We'll put the Walsh matter on for a second call, and we'll go through our list, and whenever we can get back to this case, we'll get back to it. Whatever you file, make sure you get email to Ms. Snell.
Second call means
Judge, can I
they'll
just
call it
address
again later.
the point?
Okay, Mr. Crosby?
Sure. On behalf of Mr. De Los Santos, I appreciate that Mr. De Los Santos is not a co-defendant of Mr. Walsh, but certainly there's a consolidation of litigation. So I would prefer that my client too have a second call, because I would join any relief that the court grants to Mr. Tipton and his request.
There's been no consolidation of litigation. We've been having these hearings jointly because they involve a common issue. But I've got nothing from you suggesting that anything in the materials relating to your client is problematic or hasn't been produced from the federal materials.
Oh my God.
So you're welcome to...
The defense is like, we join in that motion. The court's like, the fuck you do. You don't join in that motion. It's not your client. You can't just be like, give me whatever you give to him. They're separate cases. They're not co-defendants. They're not the same case. They're not the same victim. They're not the same facts. Whatever Tipton does, give it to me too. Give it to me, Your Honor. No. How about no? You didn't file a motion. You don't get to just copy his homework. You have a different case and a different client. Stop it. Oh my God, the judge is like, no, that's not how it works.
Stick around, but I'm not going to hold either your client or Mr. Piccio's client here for a second call, and counsel is welcome to stick around if you want. Okay? We'll put this on for a second call.
No.
Mr. Walsh.
I did have 2 motions that don't have anything to do with Mr. Tipton.
And so I'll take them up in the ordinary course. Has your client been interviewed to determine indigency?
I don't believe so, Judge.
Okay, so your client needs to be interviewed, and that'll include information about what's been.
There are 5 cases that are being heard simultaneously at the moment. And so the Walsh matter is on for second call. The De Los Santos matter, the court's like, you can stay here, but I'm not going to do anything different. And we're back to the King case and the Johnson case.
Paid so far, things like that.
Hey, Sean, can I approach sidebar on that?
Can you approach sidebar on it?
Yes.
No, we need to have an interview first, and then I'll take these under, I'll take them under consideration. Okay?
And then we interview by probation today, Judge?
We've got a long list. I don't know if probation can or can't. Mr. Tipton, I'm giving the phone back to Mr. Picho.
Do you want to do one?
No.
All right, hang on.
Judge, I also, prior to, I know you're not going to give my client a second call, but there is a pressing matter I'd like to address at sidebar with the court and Commonwealth.
Okay?
If we could? Okay.
And that white noise you hear is the sidebar noise over the jury box, which is covering the media. The prosecution and the defense are at sidebar. On the De Los Santos matter, we're going to zoom past that sidebar and the horribly grating white noise machine. And then we will see where we get to if they second call these cases, because this is a lot. All right. They turned the white noise machine back off. There we go.
That's fine.
Thank you. Thanks, Robert.
No, this is only for Miles King. This is purely for Miles King.
Do we have next dates on the other cases? So let's just run through them. But we do now have a next date on Mr. De Los Santos. What about Mr. Chanchicho?
I don't believe so. I think Johnson and Chanchicho will need another date.
How long is it going to take for the second round?
We're hoping that we'll be able to produce that by the end of the week next week.
So would we put that as well on December 4th? Put that meeting on?
Johnson and Chanchicho?
Yes, sir.
If that's okay.
That's fine, I would just ask that Ms. Chio's presence be waived for that.
I think she should be here, okay? I will not waive her appearance, so.
Oh boy.
And 2, I'll move some things around.
Judge, if I could, with respect to Mr. King, he can see probation, we're going to have time for him, but Mr. Johnson, if he goes back and doesn't see probation, he won't be able to fill out a form until the next time he's here, which would be December 4th. And the
If
information.
we can get him interviewed today, we'll do
No, I'm
it.
not looking to put any additional burden on anyone, I'm just saying, to the extent that we could get it done today, I'd be looking for access to those funds so I can give the court an update on where we are in terms of looking at the personal phone.
Okay.
We'll see. I mean, we'll see if we.
Rosemary's defendants need to be interviewed by probation, because it seems that wasn't done when they were released from custody, even though it should have been. So part of the issue is that needs to happen so that they can reappoint her as defense counsel. So some of this is just nuts and bolts foundational work. Now she is talking about getting information from Proctor's personal phone. So we have moved from what are the next dates, which cases are coming back when, which defendants need to be present in court, and then which defendants need to be interviewed again. And it sounds like both Johnson and King need to be interviewed by probation. And she is asking that be done before they leave court today, so it can get done today if probation's available today. So these are just literally logistics. If you're like, I have no idea what's going on, it's logistics. It's logistics. Logistics is what's going on. So once we get past the logistics, Law Nerds, I am still saving your questions so we can get to those after court, because I know there are many, but some of This is a very normal court hearing. There are 5 cases on, which makes it a little bit more chaotic than normal, but this is what day in and day out is like in court. What are we doing? When's the next date? What do we have? What do we not have? Who needs to be interviewed? What has been done? What hasn't been done? Why hasn't it been done? Okay, can it get done today? Because if it doesn't get done today, it might not get done between now and December, so it needs to get done. That's not uncommon. This is not uncommon.
Thank you, Mark. I appreciate that.
Thank you.
All the cases that were just on calendar, so it looks like Johnson is still in custody, and that's why she's like, can he get interviewed? Because if not, they're not going to interview him till they bring him back to court, and we're going to be in the same boat in a month. Yes, these are about Proctor's discovery. And so all of this is dealing with multiple different parts of Proctor discovery, because Proctor was on all of these cases. Nina, they didn't say when they'll come back. They didn't say when they'll come back. And not all of them are coming back, because they set December 4th as a return date for some of the defendants. The only case that's coming back today is the Walsh case. And that should be shortly. So, I'm going to see if they left the feed running. Did they leave the feed running? Because there's a second call. So they should be back on the record for second call. So the feed is still running. It's just paused. Nope. Lies. It just ended. Why did they just end the feed if they are still coming back for court? Give me 1 second. Let me see if they populated a second feed without YouTube like YouTubing at me. YouTube, calm down. Gosh. Today, anyone else having YouTube issues on your end, it's not just you. I don't see a second feed. Miguelina, will you keep an eye? Because they are supposed to be coming back into court, because that was put on second call. I just worry that the media doesn't understand what second call means. And so if that's the case, I will try to hop onto the hearing and take notes about what happens. So let's give a summary of what happened. We'll see if they go live again for second call. Otherwise, we're going to have to wait till December, which is fantastic. So a summary of what happened today. Not much happened today in court other than new dates were set in some of the cases, because the court feed cut before they finished dealing with the Walsh case, which was put on second call, meaning I will call this case again later. But I also understand that there was a lot happening in court, and then all the in-person defense attorneys left and the DA left because they're coming back. And so I understand that there might be some confusion on the part of those sitting in the media saying, wait, aren't we done? No, court's not done for the Walsh case. It's done for the other cases today. But what happened today? So today they were in court on the Miles King case, the Johnson case, the Walsh case, and the other cases all together to deal with the federal discovery from the Karen Reed case. There is a return or destroy date for the Commonwealth tomorrow, October 31st. For those of you watching this later on replay, October 31st, 2025. That date is set by court order by the federal judge. That means that the Commonwealth of Massachusetts has to give the feds back the federal discovery from the Karen Reed case tomorrow, or destroy it, but return it. The attorney for Brian Walsh said in his bare bones motion, as the court said 4 times, Your Honor, I am concerned. If this is destroyed down the road, we can't even review it to see if everything exculpatory was turned over. We have no way to access it. The defense will be prejudiced by it. And we are asking the court to issue an order that the Commonwealth maintain a copy of all of this federal discovery, because the Commonwealth has turned over information to us that is beneficial to the defense. So in argument before the court, the attorney for Brian Walsh said, I believe that the information given to us indicates that there is other information out there that may also be beneficial to us. So exculpatory or potentially exculpatory information, but at minimum, beneficial to the defense. And the judge said, well, that's not in your written motion, and there's no affidavit. But the affidavit would have to be under seal because all the federal information is under seal, so the attorney can't say in open court, well, they gave us this, and specify those things and talk about what they said because it's still under seal. So what the defense attorney said is, I will file an affidavit with the court by the end of day. And the Commonwealth said, we need to respond to it. The end of day is too far. Can we do it by 3 p.m. so we can just address it today? And then we can have further hearing on it today. And the court said yes. And the defense said, I'll do my best. Types furiously. I'll do my best to get that in by 3 p.m. So the court said, I need more information because the state level court is in the position where the Commonwealth said there was exculpatory information or potentially exculpatory information that we need to give to the defense. And the federal court order said we can give these things, not those things, and those things have to be returned to the feds or destroyed tomorrow. So there is a federal court order that potentially conflicts with what needs to happen in the state prosecutions. And if you're sitting there going, I don't even understand how any of this is happening, this all sounds strange, right? Because the fact that there was a federal investigation going on at the same time there were state level prosecutions is an incredibly unusual circumstance. And Proctor had his hands in all of these cases because the homicide unit for Norfolk is fairly small, and these are all other Norfolk homicide cases. So it is the same set of troopers and former trooper that are involved. So of course the defense attorneys are like, excuse me, can we not destroy all of it? That seems like a problem. So the judge in court in the Commonwealth, Krupp, is saying, I need more information if you're asking me to file an order that orders the Commonwealth to essentially ignore the federal order. So we are having a whole battle over, well, which court's order is going to take supremacy from one to the other. And the defense attorneys are saying, yeah, I don't care about the feds. I need this information from my client. The feds are saying, we're not going to give it to you. This is not your case. So the fight over discovery for the federal discovery continues. The state level discovery won't be as difficult. Proctor's personal phone and all the other state level information. There will be some of a court order needed to give more Karen Reed materials to these defense attorneys. Generally, a defense attorney in like the Brian Walsh case is not going to get the grand jury proceedings from the Karen Reed case and probably still won't get all of them. But as to the troopers that are involved in both cases, the defense is making the argument, we need those materials because they are so interconnected to everything else. So, what happens from here? Well, we will see if we get to see the second call in the Brian Walsh case because that's not done for the day. And the other cases are going to be back in December. So December 4th, the other cases will be there. None of the other defense attorneys said that they object to the Commonwealth returning the materials tomorrow. None of them said that. The defense attorney for King and Johnson said, I just want to make sure that the items listed in the index from the federal materials, the state grand jury transcript, and the Commonwealth level police reports, I want to make sure that those things do not get returned. And the court said, those are in the possession of the Commonwealth. That's not a problem. And she said, okay, if that's not a problem, then that's fine. So Goosebump 801 said, why would the other defense attorneys not have an objection to the return or destruction? It might be because, well, there could be a ton of reasons, but it might be because the information in the Reed case doesn't really overlap with their case in the same way that it might in Walsh. So it just depends if what they saw applies to their cases specifically. They are all differently situated. And it might be that based on what they've been turned over so far, the other defense attorneys are like, oh, the stuff from the personal phone that goes back further is going to be more helpful. So we'll see. It also is going to deal with which troopers are involved and how. I don't know who the lead investigator is for each of these cases. It might be that in some of these cases, Proctor was lead, and some of them he wasn't. And so it's not as intertwined. So all of the defendants are in a different circumstance. All of their cases are different. I mean, there's 2 that are co-defendants, but still. And so they're differently situated. Though we did see the defense attorney for De Los Santos saying, whatever Tipton wants to do, I want to do that. And the judge is like, oh my God. Custom Shadow said, I'd love to understand this a bit more. Shouldn't it be the same material? The federal material is the same, but the relevance and exculpatory nature of it could be different to each defendant because each defendant has a different case, a different investigation, and a different level of interconnectedness. The federal material is the federal material, but how it relates to each other case depends on those cases. Chicky said, are they all murder cases? Yes. Which is why they're all intertwined here, because it is the Massachusetts State Police troopers that do those murder investigations in this jurisdiction. And that's why this is so interconnected, because it's all the same people. I'm going to answer a few more questions, and then we will see where we're at. Because if I need to hop on and listen to the Zoom so I can tell you guys later or tell you in the app, I want to be able to do that. So let's answer some questions. I don't know if they're going to pick this hearing up again, but we're going to answer some questions and go from there. I understand it's confusing and it feels like a total cluster. It is and it isn't. There's a lot of moving pieces. And I get where the defense is frustrated. I get where the court is frustrated. S Cubed said, what makes the Walsh case more relevant? I don't know. It's Walsh's defense attorney's perception. Also, Walsh is supposed to go to trial next month. Walsh, I think, of all of these cases, to the best of my memory, Walsh is the homicide that occurred most recent in time. So the federal materials may cover the time frame of Walsh's investigation more squarely than some of the other cases. Also, each defense attorney gets to decide how it impacts their own case. So it is also how each defense attorney sees that material. So time might be a thing, but it's hard for me to say because all of those federal materials are sealed. So we don't know exactly what's in all of them. We have a rough idea of the things that came to light in the Karen Reed case, but we don't know what else there may be. And I also don't know if there is digital evidence in the Walsh case, which officer or trooper is the one who handled that. And were they also a witness in the federal case? Is that different than in the King case? And so there's a lot of potential overlap. And then there's areas where there might not be as much overlap. So it really, really, really just depends. And here we are. Lyndon in the chat said, to be fair, Judge Krupp said last hearing it was against his better judgment to have a hearing today. Yes, he was already like, oh my God. Oh my God. But I do want to see if there is going to be more hearing today, and I want to make sure that I don't miss that. So I get it. It is very frustrated. Richard said, this is what we rescheduled food court for. You never know what's going to happen in court. It could have been a day that was much wilder. It could not have been, but we voted and we did food court yesterday. I'm glad we did because we had plenty of time for food court yesterday. We would not have had as much time for food court today because I do have family stuff with the kiddos this afternoon. So Rocketus said, can't hear shit, Captain. Yeah, that's exactly how the beginning of this felt. Natalie said, how was Proctor's personal phone subpoenaed again? How did they know there was work stuff in the personal phone to unlock all of this? The federal materials, I think, linked all these together. That is my understanding. Some of the stuff we just don't know. Indigo said, happy Halloween, law nerds. Happy Halloween to everybody. Trisha said, what is the rush to destroy all things considered? There's a federal court order with a date on it. And that date's already been pushed a couple times. So it's the federal court order. That's why. Otherwise, this wouldn't be happening. The state or the Commonwealth normally wouldn't do this like this. But the feds said, we gave you this material for the Reed case. The Reed case is over. Give it back or get rid of it. Period. This is not for other cases. This is for this one case. The feds are like, no, there are also rules federally. You can't just. So, Ashley said, loving the skeleton earrings. I actually did find them on sale on Amazon. So I linked them in my Amazon link for you because on YouTube, they would only link them from a different location that had them for like $30 more. And I'm like, I'm not looking at that. So I have them linked in the Amazon shop. Forever Wander said Norfolk is Norfolking today. The court had so many things on calendar today. So even though we're not seeing what's going on in court, there are other matters going on in court. Let's see. David said throwing in 20 so we cannot do this twice. I really need that attorney to just look, even an AirPod, like if you get a newer like AirPod, it will pick you up better on Zoom than whatever is happening. Do not use the microphone on your computer. It is not going to work. It's not going to work. Denise asked, why does anything get destroyed? I don't understand that. The federal court order. And destroyed is the alternative to giving it back. So give all the material back. But then again, if there's the destroyed would go to if there's files saved on your computer, you need to delete them. You need to return the digital copies to us, and you need to not still have a copy. So all of that. Music to My Soul said, do you think the judge is being somewhat inconsistent by saying the others can't join in Tipton's motion when he allowed the lawyer he denied to stand in multiple lawyers in the last hearing? I don't think so, because it's a different thing. Standing in for an attorney and saying, I'm representing this client, I'm setting new dates, I've talked to this attorney, this work is totally different than joining in motions on unrelated cases. So no, the judge is saying procedurally, we are following the procedural rules here. And if you don't follow the procedural rules, I can't help you. So the judge is like, you've just got to, literally, you can't ask me to order the DA's office to essentially violate a federal court order without more than a bare bones motion. Like, you've got to give me more to justify this because it is going to be a fight. Let's see. Who is the attorney that looks like Lally? I don't know. It is hard for me to keep all the names straight because we have seen different couplings of these attorneys in court. It is difficult for me to keep their names straight. We only hear from some of them sometimes. They don't always announce their appearance before we hear from them. And we're not covering all of these cases. It's the discovery issue.